Back after a long holiday weekend. Happy Labor Day to everybody. It is Tuesday, September 2nd. We're here to talk mass torts with our friend Joe Fantini. This is Jon and Marc. We're going to start out with Paraquat, with the first trial scheduled to kick off in Philadelphia in early October, coming up here just in about a month. But a recent filing indicated that some cases in the MDL and in the JCCP have settled. What are you hearing about this litigation, Joe?
Yeah, John, like you mentioned, the first trial is scheduled to begin in October in Philadelphia Court of Common Pleas. The previous bellwether trial in Philadelphia is settled right on the verge of trial. So I know the parties are in mediation related to that bellwether case that's scheduled to begin in Philadelphia. And they're also talking about some additional cases. There was this really interesting filing that we saw out in California State Court. So there's a consolidated action there in the JCCP. And what this filing indicated was that there was a master settlement agreement between the defendants and the plaintiffs that covered cases filed before April 7th, 2025 for filed cases in the JCCP and the MDL. Basically, it indicated that the individual plaintiffs would be getting a settlement award offer sometime in approximately 90 days. Those cases look like the majority of them have settled. Meanwhile, the Philadelphia action's moving forward. We'll see if in the next month or so we can get resolution in Philadelphia, and then that'll finally bring about an end to this litigation that's been going on for 5+ years.
Very exciting news.
Yeah, that's definitely a good development. Things have been quiet since we heard about a preliminary agreement between the parties in the spring of this year, so good to hear that some of these plaintiffs are going to be getting offers before the end of the year.
On to the next one, mixing up a little bit. So sex abuse. There's been a lot of buzz about sex abuse cases becoming the next big mass tort. Are there any recent noteworthy developments in this front?
Yeah, like you mentioned, there's a lot of excitement here going on about potential cases for sex abuse. Usually we've seen them go after specific facilities or institutions. Right now we're starting a really big trial against the Archdiocese in New Jersey State Court. The jury selection scheduled to kick off today, and we'll see if this case ultimately goes to verdict. But what we've seen is a number of jurisdictions expanding the statute of limitations, allowing for a look-back period, and we have a couple dates that are coming up on potentially expanding that into 2026. One such state is Pennsylvania, where there's been discussions about allowing minors who were abused having additional time, maybe 20 years, 30 years from the date of the abuse to bring claims. So I think in 26, this is going to be a really hot litigation. It's going to be really specific, related to specific institutions or the Archdiocese or the Latter-day Saints. There's a lot of focus on those type of cases, so we'll be hearing a lot about that. I expect it upcoming mass tort made perfect.
This has been happening for around 5 years now, where you've got the windows opening up. You had New York open up, New Jersey open up. California set their permanent window for anyone under the age of 40 to have that look back. It's definitely interesting to see all of this progress happening. We also saw windows opening up in Louisiana, I believe, Colorado, but we haven't seen a lot of case acquisition or marketing happening in those jurisdictions. Are there any nuances about those specific windows opening up that make them less favorable to plaintiffs?
No, those are definitely some jurisdictions that were favorable. We saw out in California a recent settlement, a huge settlement for a juvenile detention facility. Basically, the issue with these cases is finding an entity or an institution that has funds to pay for these settlements and who you can go after. So that's why I think we're going to see a lot of cases going after potentially the Archdiocese in the different states. Like I mentioned, these Latter-day Saints, there's some rumblings of litigation or tolling agreements involving them in different jurisdictions. So a lot of victims out there, unfortunately, but finding somebody who has the funds that we can go after to get them compensation is really the hurdle. So we have a handful of states that have already done that. I expect this to continue to be an issue and more states getting on board in the next couple years.
I'm interested to see how this progresses because there are a lot of states who have changed the lookback laws to help the victims of these cases, but then have also opened themselves up as the state because they were perpetrating these offenses as well to huge exposure from a liability perspective. So I'm interested to see as this progresses, which states open up windows as well as capping their potential liability like Maryland did after the fact when they opened the window.
Yeah, that's a great point. And even some states like in Pennsylvania, there's caps, unfortunately, on damages against a government entity. So for each claim, it could be capped at $250,000 or $500,000. And there's disputes about whether that would be per incident or, per one accuser. So the states do that. We usually need to find some sort of private entity outside of the state. Sure, they have some liability to contribute some money, but usually it's, like I said, against the Archdiocese Latter-day Saints. So it's going to continue to evolve, but this just shows the good work that plaintiffs' attorneys have done. Because if it wasn't for us beating this drum, fighting for this for over the past decade, there'd be no change and nobody would be held accountable.
Yeah, we're definitely seeing a lot of progress in juvenile detention facilities with all the news around them. California, Illinois, Washington, all across the country, it's becoming much more of a hot topic. And you're right, plaintiffs, lawyers, and the industry as a whole enacting change for the better of society. It's great to see that. Moving on to AFFF, we do have an upcoming deadline there. We've been talking about this for the past few weeks. What are you seeing now in terms of new case filings, and what do firms need to know after they file their cases?
Yeah, John, we've been talking about it for a couple of weeks here. It's the hottest topic of mass torts. That's why we're on it again this week. Since we first talked about CMO 35, we've seen more than 40,000 new cases filed. So right now we're at a sprint to the deadline of September 5th. And then what's really important is everybody needs to review CMO 35. Basically, you're going to have about 90 days from the date the complaint is filed to meet certain requirements. So you're going to need to have records that show the top 6 injuries, confirmation of that. And then if it's a water drinking case, you're going to need to have the ID of where that specific facility was. So just because you get the cases on file, that's the first hurdle. Make sure you do your clients right and you're able to get the records, produce them, and then also supply the information related to where they were exposed. So a lot of work still needed to get done. Like we said a couple weeks ago here, we're thinking about 100,000 total filings. It'll be real interesting when we connect next week to see if we're able to reach that number.
That's an insane amount of filings. We'll see where it goes. Next one. This is on the list. I've been waiting for an update on this for many, many years now. Talc. We are nearing nearly 70,000 filed cases in the MDL, but have the first mediation scheduled for later this week. Are you optimistic about this upcoming mediation?
I think I am. For the first time in a while here, this is one of the legacy mass torts we've been talking about, more than 10 years in the making, a couple of failed bankruptcies. J&J put up some serious money, over $9 billion to resolve the cases. Recently, earlier this year, the judge appointed some new leadership on the plaintiff side to lead this mediation. So I don't expect a breakthrough here in September or October, but I do remain optimistic within the next 6 months we can get a global settlement and get these cases resolved in the MDL and in New Jersey State Court. And in addition to the mediation, it's going to be the pressure being applied by the upcoming bellwether trials. So just having the mediation, that's not going to be enough to get it done. But when we have a number of trials on the docket coming up, potential huge numbers that J&J could face, in addition to the bad news deteriorating their reputation, that's what I think is going to drive a settlement. So I'm going on record here. I'm feeling confident within 6 months we'll have the framework for a global settlement and Talc and finally get these women some justice.
Wow. You think it'll be all resolved in 6 months? Where do we currently stand with the attempt to file bankruptcy? Is that just completely off the table now?
Yeah, Texas two steps dead in the water here. So we were able to fight that back a number of times. There were a couple failed attempts by J&J, and after the last time failed, they said they're done doing it. They're not going to try to go file another bankruptcy. They want to litigate these cases in court. That's what they say. Realistically, what I think that means is a couple cases are going to get worked up. we're going to have this mediation going. There seemed to be some disagreement and distrust between the leadership on the plaintiff side and the defendants, some really bad blood, some personal attacks in these filings like you usually don't see. And now there's somebody new there for plaintiffs. So I'm hoping that's going to help bring about this mediation, bring about a resolution that everybody's happy with. Like I said, J&J's already offering $9 billion. So we're starting there. We'll see how high we can get it up to. But I think in the next 6 months, we'll have some real positive news in this litigation.
Great to see some progress there on a litigation that's just been lagging for years and years and years.
Yeah, through no fault of our own, right? J&J just kept filing bankruptcy, and each time they did that, under the rules, the act of litigation automatically got stayed. So we'd win a bankruptcy ruling, J&J would kind of go through it again in the next couple months, file it, and that stayed the litigation almost for a year each time that happened. So now that's out of the way. We can move forward with the cases, get some cases to trial, get some verdicts, hopefully get some big numbers up there, put some more pressure on them, and get this litigation over once and for all.
I think it's important to note that while mass torts are unrelated to each other and the defendants, the team that was able to defeat the bankruptcies takes another tool out of the tool belt for the defendants for other mass torts to use to delay the process even further. So this, while unrelated, it is helping the entire industry as a whole for people to get compensation for victims moving forward.
Oh, that's a great point. Beating this last Texas two-step attempt by J&J, the biggest thing that happened in mass torts by far, even though these specific plaintiffs in the Talc litigation haven't seen any compensation yet, it was huge for the plaintiffs bar overall and limit severely what the defendants can try to do in other mass torts.
Absolutely. Joe, thanks again. Great update today. We hit all the high notes: Paraquat, sex abuse, AFFF, PFAS, talc, all in under 15 minutes. This is the place every week to get your updates on the latest mass torts. It's Tort Talks with Joe Fantini, Jon and Marc. We'll catch everybody next week. We're already here in September. Have a great week, everybody.
Thank you. Thanks, Joe.
Thanks, guys.